Good morning. Dear colleagues, members of the Secretariat, our dear friends from the public, conference services, interpreters, welcome to this 3223rd meeting of the Human Rights Committee. This is a public meeting today to consider two reports, and they are follow-up or progress reports. Firstly, concerning concluding observations, and then concluding views on individual communications. So, as usual, we'll begin by hearing Ms. Cleveland, the Special Rapporteur on follow-up to concluding observations, give her progress report. And I think you have that report in your files. It was circulated last week. So I imagine you've had time, colleagues, to have a quick look at that. We'll go country by country through the document to see if we can adopt the document. And I'd like to thank the Special Rapporteur for the report and give her the floor for an introduction to the draft report. Ms. Cleveland.
Thank you, Mr. Chairperson. I would like to start by thanking Ms. Santana and the Secretariat for their indispensable assistance in preparing the report. The report reports on follow-up for 8 countries: Armenia, Kenya, Paraguay, Albania, Finland, Tajikistan, Nepal, and Georgia. And I would like to express my regret and to some extent my frustration that the 10,700 word limit on the report required us to not include Iceland. So once again, we were not able to provide feedback on follow-up for a country in as timely a manner as we would like due to the word limits. And perhaps more importantly, it requires on occasion so severely cutting the information provided by the state and or by civil society that it can make it very difficult to understand the committee's conclusions with respect to a particular country. So I find it quite arbitrary to apply this word limit to these follow-up reports. That said, I will turn to Armenia, which is the first country in the follow-up report. Actually, one other introductory comment I would like to make. C2, the assessment of C2, covers a response received but not relevant to the recommendations. Consistent with the committee's practice, we give a C2 to countries that report, but the information that they provided us is the same information that they had provided us before the dialogue and before we issued our concluding observations. So such information, because it's not relevant to the follow-up, receives a C2, and that has been our practice in this report. Okay, Armenia, this is the follow-up to the second reply. The concluding observations were in July of 2012. The second reply was received in June of this year. With respect to paragraph 12, it asks the state to establish effective investigative procedures to ensure law enforcement officials are responsible for excessive use of force during March 2008 events, that those responsible are held accountable and sanctioned, and that victims are compensated. In our first follow-up, in which we gave the state a C1, we noted that they hadn't referred to information taken since the concluding observations. We asked for further information on measures taken after the concluding observations, sanctions imposed, and compensation provided to victims. We've provided a summary of the state party's reply, as well as information from civil society. And our evaluation with respect to this recommendation is a C2. We once again regret the failure of the state to provide information regarding measures taken since the adoption of the concluding observations, and we reiterate our request in that regard. With respect to paragraph 14, this requests that the state establish an independent system for receiving complaints regarding torture or ill treatment, and that any act of torture be prosecuted or punished. The follow-up question welcomed efforts taken to establish an independent mechanism, but noted that the recommendation had not yet been implemented. We asked for further information on when the state party intended to implement an independent mechanism and reiterated the recommendation. The state, in reference, refers to a draft law that was tabled in 2011 and repeats information regarding a national action plan. NGOs indicate that no notable changes have been taken, and our assessment here is a C2, again for the failure of the state party to provide information that is subsequent to the concluding observations, and we ask for additional information regarding the pending legislation. The final paragraph, paragraph 21, recommends that the state amend its domestic legal provisions to ensure the independence of the judiciary and consider establishing an independent body responsible for the nomination, appointment, and promotion of judges. The initial follow-up welcomed a strategic plan, but found that it did not implement the recommendation, and the recommendation was reiterated. The state's reply here refers to the entry into force in July of 2014 of amendments to the Judicial Code, which introduce written tests in criminal, civil, and administrative fields for entry into the judiciary, as well as psychological tests, as well as a qualitative and quantitative system for evaluating judges' activities. On this, we give the state a B2. We welcome the adoption of the amendments to the Judicial Code. We ask for further information on them, including further measures to establish an independent body for the appointment and promotion of judges, the current role performed by the executive and legislative branches, the purpose and criteria and procedure for the psychological tests, and for any information regarding, internally or externally, regarding the quality and impact of the procedures. And I would note that last recommendation is because although we know that the state adopted amendments to the Judicial Code, we don't have detail regarding what those amendments were, and it is hard for us to assess, based on the information the state provided us, how much they help promote the independence of the judiciary. There is a Venice Commission opinion on the draft law, which we did review in part in making the assessment that we did. So I'll stop there, and I welcome comments on Armenia. Thank you.
Thank you, Ms. Cleveland, for your work. Allow me now to give the opportunity to colleagues to take the floor, if they have any comments on the proposed follow-up to the different concluding observations on Armenia. Would any colleagues like to comment? Mr. Rodriguez-Recia. Good morning, and I'd like to thank the rapporteur for her excellent report. Allow me to thank the Secretariat as well. It's not really specifically on Armenia, but with regard to your general comment on the concern that you've had to leave out a country because of the word limit, I think that's an issue that really requires a more in-depth discussion at another opportunity, because with regard to follow-up to countries, this word limit should be looked at very carefully. I don't really see the point if you look at the effects of the analysis on the country. I think it's putting us all in a very difficult straitjacket, and we really need to send out a clear message that in country follow-up reports, the word limit really needs to be changed so we have more space. Thank you. Thank you, Mr. Rodriguez-Recia. Any further requests for the floor? Well, I don't see any comments, so I have to questions. Firstly, I fully agree with the assessment of the rapporteur. And it's true that it's difficult for the follow-up rapporteur when the committee decides on a very broad follow-up paragraph on measures, and this is with regard to judicial reforms. It always gives the special rapporteur a lot of problems, and it's very difficult when it is so broad. So I'd urge the committee to bear that in mind when it decides the effective paragraphs for follow-up. And then secondly, I fully share the rapporteur's concern and the concern pointed out by Rodriguez Recia on the number of words, the word limit. This isn't the first time that this has happened in the committee. 2 years ago, we had to leave out the report on countries that had done all the work, and we were ready to comment, but because of the word limit, we couldn't include those comments in the report. And it just undermines our work. So I think at this point we can adopt the draft on Armenia. Thank you to the rapporteur, and I'll give you the floor back to talk about Kenya. Ms. Cleveland, you have the floor.
Thank you, Mr. Chairperson, and I would like to thank Mr. Rodriguez Recia for his remarks as well. With respect to Kenya, this is the first follow-up. The concluding observations were issued in July of 2012, and the state's reply was received late in February 2015. With respect to paragraph 6, this paragraph asks the state party to strengthen its efforts regarding the participation of women in public and private sectors, including the possible inclusion of temporary special measures as appropriate. We recommended that the state party ensure that the two-thirds rule enunciated in the Constitution is implemented, and to include disaggregated data on the representation of women in its next report. In its reply, Kenya iterates its commitment to promoting the equal participation of women in public and private sectors. It notes that in 2013, the court ordered the state to develop policies and increase participation of women in the political process. The Constitution establishes that not more than two-thirds of the members of an elected body may be of the same gender. This provision has been upheld by the Supreme Court, and the Attorney General set up a working group on how to implement it, but it has not been implemented. In the state reports that after the 2013 general elections, 6 women were appointed to the cabinet, and that a survey is being undertaken regarding implementation of the two-thirds rule. We also received information from civil society. With respect to this recommendation, we assess a score of B2. We welcome the representation of women in governmental positions and the efforts of the state with civil society to undertake a survey. We regret that the two-thirds rule has not been fully applied. We request additional information on measures taken to strengthen the efforts to increase participation of women, including the work of the working group established by the Attorney General. And we also ask the state to respond to allegations of violence that we were provided by civil society faced by women running for election in 2013. With respect to paragraph 13, this recommendation asks the state as a matter of urgency to pursue cases regarding the post-2007 election violence to ensure they are investigated, prosecuted, punished, and victims compensated, and that the state party should implement the recommendations of the Commission of Inquiry that was conducted into these events. The state says that the Director of Public Prosecutions established a task force to conduct a countrywide audit to determine what investigations are being undertaken. It says there were a total of 191 convictions out of 6,443 cases opened. 61 cases are pending investigation, and they outline the status of implementation of the recommendations. Civil society has expressed significant concern that the state party's information, on the one hand, repeats information from before its appearance before this committee. The Kenyan National Commission on Human Rights indicates that with over 8,000 cases that have been reviewed relating to post-election violence, only 2% involve prosecutions that secured convictions, and where there were convictions, no compensation has been granted. So with respect to this recommendation, we give the state a C1. We regret that the available data indicates that only a small number of cases have been prosecuted and convictions have been rare. We reiterate the request to thoroughly investigate all cases and compensate victims. We also ask for statistical information regarding convictions and acquittals since the state party's appearance, since that was not clear in the state's report, as well as updated information on the effort to establish an International Crimes Division of the High Court. Finally, with respect to paragraph 16, this paragraph asks the state party to take urgent measures addressing overcrowding in detention centers and prisons, develop alternatives to detention as a form of punishment, to ensure that allegations of torture and ill treatment are effectively investigated, prosecuted, punished, and compensated, to ensure that law enforcement personnel receive training consistent with the Istanbul Protocol, and finally, that to ensure that the Prevention of Torture bill includes a definition of torture that is in line with Article 1 of the Covenant. The state mentions that the Persons Deprived of Liberty bill regarding incarceration should be enacted by August 2014, but they did not confirm its enactment. They note that there has been an increase in the use of community service orders for petty offenders as an alternative to incarceration. The Independent Policing Oversight Authority, they note, can take over investigations, but it's not clear what investigations or if this is a change for prior practice. They say the Istanbul Protocol has been included in police training curricula, and that the Prevention of Torture Bill of 2014 defines torture in full conformity with the convention, and that this bill is under review. Civil society notes that as a result of a presidential pardon, there has been a slight decrease in overcrowding because 4,000 detainees were released from prison, and that although in 2013 and 2014, 278 cases of torture and inhuman or degrading treatment were documented, no police officer has been charged. The state owes victims, according to a state assessment, the state owes victims approximately $2,400,000 US in compensation for torture, but no budget has been allocated to pay this. Here we assess a grade of B2. With respect to overcrowding, there has been some decrease in prison crowding, but we require additional information on the measures taken to guarantee that this occurs systematically, particularly with respect to alternatives to imprisonment, and we ask for statistical information on prison overcrowding. With respect to the obligation to investigate and prosecute and punish acts of torture, we note the establishment of the Independent Policing Oversight Authority, but it is not at all clear what efforts have been taken at all. We note the civil society information. We give the state here a C2, requiring additional information with regard to the impact of this mechanism, because otherwise it's not at all clear that any new measures have been taken. With respect to training of police, we give the state a B2, welcoming the incorporation of the Istanbul Protocol, but asking for information regarding the actual number of trainings that have been carried out or are scheduled to be carried out, and other detailed information regarding them. And then finally, with respect to the inclusion of the definition of torture in the Prevention of Torture bill, I believe this grade is actually an error because the state did in fact respond, and I think the draft had given them a C2 before we appreciated that the state had responded in this regard. And so because there is a bill pending that the state contends is consistent with the international definition of torture, I would recommend that this score be a B2 instead of a C2. And that's my report on Kenya.
Muy bien, muchas gracias.
Thank you very much. Mr. Sittlesing, you have the floor.
Thank you, Chairman. We thank Ms. Cleveland and the Secretariat for this report and the concluding observations. I just had a small query concerning paragraph 13 of the concluding observations, and that comes at the end, just before paragraph 16, that we updated information is also required an initiative to establish the International Crimes Division of the High Court. I'm a little bit puzzled by this appellation of an International Crimes Division of the High Court. I suppose, was it? I wasn't present when Kenya was examined. I wasn't a member. So did Kenya itself say it was going to establish an International Crimes Division, or did we recommend it? Because surely it's quite puzzling, because it's not within a country, if crimes have been committed, they are crimes. Why should this be an International Crimes Division? But if it is Kenya who made this proposal, of course, well, we can't add anything to it, but it sounds puzzling to me. Thank you.
Bien, muchas gracias.
Thank you very much. Would anyone else like to take the floor? Mr. Politi, you have the floor.
Thank you, Chair. I had the same query. I would like to thank Ms. Cleveland, obviously, and the Secretariat for this excellent work. I had the same query as Mr. Sittlesing regarding this part of the report and the latest sentence before the discussion on paragraph 16. Together with the question asked by Mr. Sittlesing, I wonder, do we know what suspects exactly we're talking about, those suspects that were not being taken to The Hague? I know that there are arrest warrants issued on the situation on Kenya for crimes against the administration of justice that have been recently issued by the ICC. Are these the arrest warrants that we are talking about? Is there any kind of agreement with the court, which I doubt, that Kenya would try these suspects in Kenya instead of sending it to The Hague? I have doubts about this kind of agreement based on the establishment of an international crimes division. So some clarification on this point would be welcome, if possible. Thank you.
Muchas gracias.
Thank you very much. I return the floor to the rapporteur, Ms. Cleveland.
Thank you, and I appreciate the questions about the International Crimes Division. This reference is a casualty of the word limit because Kenya provided actually a lengthy response, and we had to severely edit Kenya's response in order to comply with the word limit. Among the things that Kenya reported on that we were not able to address in detail, they state that the Special Tribunal for Kenya Bill and the Constitution of Kenya Bill were not accepted by the Kenyan Parliament. The state party expressed plans, however, to set up an International Crimes Division of the High Court that would try those suspects who have not yet been taken to The Hague and that will adopt similar procedures as the ICC. The Special Division of High Court will not only prosecute committed crimes, but have a procedure that will attempt to prevent future crimes. That's the information we were provided. We were not provided any further information, and so for that reason, we requested further information with respect to this as part of the follow-up. Thank you.
Muy bien. Muchas gracias por la...
Thank you very much for that explanation. Nadia raised an issue in terms of differences in this this assessment as proposed by the rapporteur, and so we can suggest that change, as Ms. Cleveland had said. Do we agree with that? Very well, we can accept Ms. Cleveland's proposal. You have the floor, sir.
Yeah, thank you very much, Chair, and good morning, colleagues. In an attempt to respond to Mr. Situ Singh's inquire about an international crimes division. If I may give you the experience of Uganda, which I'm familiar with, they established one such because of the referral that Uganda made to the ICC in respect of the Joseph Kony and the Lord's Resistance Army situation. And as you are no doubt aware, the ICC is a court of last resort where if the state is unwilling or unable to, prosecute these people who would have committed those similar crimes. Now, if somebody engages in mass murder and things like that, and you charge them with common murder, it doesn't quite get to the because crimes, the international crimes are the crimes that rub the conscience of the international community the wrong way. And some crimes in the domestic criminal code may not be crimes in another jurisdiction, but international crimes are cut across. And that was the rationale for forming the International Criminal Division. In Uganda's situation, they had a lot of help from the International Criminal Court and both from the prosecutor's side and then the judges. And there is one case going on. The person could be well charged with common assault or murder, the ramifications of which are, because the punishment, Uganda's statute book still has the death penalty. But in the case of international crimes, there is no death penalty, which is kind of paradoxical because, but that's the rationale. There are some crimes which could be tried in the, in the domestic criminal code, and then the one which is, hurts the conscience of the international community. Thank you.
Bien. Muchas gracias.
Very well, thank you very much. Mr. Politi, would you like to speak again?
Second only, I would like to suggest a small change in the penultimate sentence here. Instead of saying which would try those suspects who had not yet been taken to The Hague, which is confusing because it seems as the court has agreed already that don't take them to The Hague but try themselves. This would require a very complex decision on complementarity. I'm not aware that this decision has been taken by the court. Why don't we say which would try those suspects of the most serious crimes under international law, something like that. If Ms. Cleveland would agree with this, I'm perfectly okay with the rest of all the other assessment and
Bien.
draft. Thank you.
Señora Cleveland.
I appreciate the ambiguity of this statement. It actually is what the state told us with respect to the authority of this tribunal. We're basically quoting the state's claim that it will, quote, try those suspects who have not yet been taken to The Hague. And so we were trying to reflect what the state had said as accurately as possible. But I'm happy to confer with the Secretariat to see if there's something else that can be done in this regard. Thank you.
Bien, muchas gracias. Quizás
Thank you very much. Perhaps Perhaps we can put quotation marks there in that section so that we make it clear that we are textually citing what the state has stated. And with that, I think we can adopt the proposed evaluation, and I return the floor to Ms. Cleveland to present the follow-up for Paraguay. You have the floor.
Thank you, Mr. Chairperson. Paraguay's concluding observations were issued, I should correct the date, it was March of 2013, not December 2014, and we will fix that in the final version. Its first reply was received timely in May 2014, and its second reply was received timely in April 2015. Paragraph 8, the first recommendation paragraph, addresses accountability for past crimes committed under the military dictatorship and up to 2003, including the ongoing search for the remains of victims of enforced disappearances. The follow-up question in the initial follow-up that the committee had issued asked for additional information regarding the progress of judicial cases concerning violations that occurred during the dictatorship, actions taken by the Human Rights Directorate of the Supreme Court of Justice on cases opened after 2013, the new criteria that the state claimed were being developed for compensation, and the internal deadline for issuance of decisions on compensation, as well as additional information on the allocation of funds for the purposes of searching for human remains in the context of enforced disappearance investigations. The state reported that the Human Rights Directorate of the Prosecutor's Office is classifying the files of missing persons, and that there are a total of 97 cases under investigation. They indicate that a Museum of Justice is to be established in 2015, which is planned to establish an agreement on judicial cooperation in searching for missing persons from that era. They say that the Attorney General's office has not yet established criteria for granting compensation. There's a 21-day time period for the processing of compensation claims. They state that since 2006, they have found a total of 29 bodies. There are 20 more places where searches need to be conducted. With respect to the 29 bodies, and here there's another correction in the last paragraph above the committee's evaluation on page 9, the dollar figure is $75,000, so there should be a period rather than the comma at the end of that figure. It would be nice if it were $75 million, but it is in fact $75,000 that was approved for this project. With respect to this information, we give the state a C1. It's not clear how meaningful the efforts of the Human Rights Directorate are to classify the files of missing persons. We ask again for information on the progress of judicial cases that were since the adoption of the concluding observations. We ask for the number of cases that have been analyzed by the Human Rights Directorate and the results of its classification efforts. We ask for the number of prosecutions, particularly those launched since the state party appeared in 2013. We ask for more information on the potential agreement for judicial cooperation, on reparations and compensation. So in short, the state party provided a good bit of information, but some of it was old information and a lot of it was of unclear relevance to the specific questions that the committee had asked. So we've asked for further clarification. With respect to the identification of victims of disappearance, we give the state a B1, welcoming the information provided and ask for additional information on the progress to initiate the identification process and actions taken to allocate the budget that is required. With respect to paragraph 14, we ask the state party to review the functioning of, quote, neighborhood watch committees and hold accountable persons in those committees responsible for criminal acts and compensate their victims. In the follow-up, we gave the state a C2 because the recommendation had not been implemented, and we reiterated the request. And here, the state party again refers to information provided in its previous follow-up report, and so we give the state a C2 for failure to provide any new information. With respect to paragraph 23, finally, this paragraph asks the state to institute an investigation into the deaths of 17 people during the police raid in June 2012 and into related incidents, including other human rights violations, as well as a young person who was convicted and 2 heavily pregnant women who at that time were held in pretrial detention. In the follow-up question, we took note of the criminal proceeding the state had launched, but required additional information on its progress. In its reply here, the state says that the public prosecutor concluded that police involved in the events of June 2012 acted in legitimate defense, but those proceedings apparently remain under judicial review. So the public prosecutor thought there was not a violation, but apparently they are pending. The state's information is unclear in this regard. They say investigations are ongoing with respect to alleged acts of torture committed by police officers, and the 2 heavily pregnant women's detention was replaced by house arrest in March 2013. Here we give the state a C1, noting the information regarding the criminal proceeding that was launched, but we request additional information on the number of persons accused, crimes committed, and the outcome of the proceedings, as well as the progress on investigations into alleged acts of torture. And that's it for Paraguay. Thank you.
Muchas gracias.
Thank you very much, Ms. Cleveland. Would any members of the committee wish to speak in relation to this evaluation? I see none. If you will allow me, I would like to raise a question. I agree with the proposed evaluation, but I think this is a clear example of the difficulties that we can run up against when proposing an evaluation, when in the evaluation criteria we have various aspects mixed in terms of substantive and formal aspects. Here, there is no doubt that replies have been received, but that the replies do not fully cover the concerns expressed by the committee. I'm not going to propose a different grade. However, I will look to Ms. Cleveland as rapporteur on follow-up on concluding observations, and Mr. Rodriguez-Recia as the rapporteur for follow-up on individual communications, and think whether we can come up with some criteria which would be better adapted to the way we work in the committee. I just wanted to raise this as I thought it would be an important point to touch upon. I don't know whether Ms. Cleveland would like to make any comments on what I have just said as a rapporteur.
No, Mr. Chairperson, I agree with you. I believe that the criteria that the committee has developed, while useful, are complicated, and their interface with what are often quite complicated recommendations can make the follow-up effort difficult for both the committee and states. And so I think if we can try to ensure that we focus our recommendations for follow-up, as well as perhaps look at the criteria for follow-up on both views and concluding observations with an eye towards simplifying them, it would be helpful. Thank you.
Muchas gracias, sí.
Thank you very much. I think we do agree there. So I will return the floor to you, Ms. Cleveland, to present the next state. You have the floor.
Thank you, sir. The next state is Albania. This is the first reply. The concluding observations were issued in July of 2013. The first reply was received late in July of 2015. Paragraph 9 asks the state to intensify its efforts to conclude its investigation into the January 2011 demonstrations, bring perpetrators to justice, and compensate victims. Here, the state provided a somewhat complicated reply. The Judicial District of Tirana Court had previously found 3 citizens not guilty on charges of homicide related to the January 2011 events, including relating to the deaths of 3 individuals. On appeal in 2013, the prosecution sought to reopen convictions for 2 of these defendants on the lesser charge of homicide because of negligence, seeking sentences of 1 and 3 years. Apparently, that appeal is ongoing even though it was launched in 2013. The state then indicated that a separate criminal investigation was underway regarding a different individual, as well as a criminal investigation of the prosecution office of the Tirana Judicial District into arbitrary actions of the police. Both of those were initiated in 2011, and so they are not new information for the purposes of the committee. So the only new information that we have relates to the appeal, which apparently has been pending for several years, of the prosecution of the 2 individuals. NGOs state that the state party has failed to conduct an effective criminal investigation and that no investigations in particular have been made into whether higher-ranking police and state officials hold any responsibility. Here we gave the state party a C1, regretting that the investigation was still ongoing into the January 2011 demonstrations. We had asked them to conclude the investigation. That was our core recommendation. And we asked again for additional information on efforts to intensify the investigations and ensure compliance with international standards. We give them a D1 on compensation because the state provided no information on measures taken to compensate victims. Now, I will note the second sentence of this assessment refers to information that was provided by NGOs, and I think perhaps we will try to clarify that fact. We didn't have room to include this information from NGOs in the summary of their submission, but NGOs had indicated that there was a pension that was to be granted to victims' families who will qualify, and so we asked for information in this regard, including the amount and duration and whether pensions have already been granted. But this was NGO information. It did not come from the state party, hence the D1 assessment. With respect to paragraph 13, we recommended that the state should ensure proper implementation of pre-screening procedures at the border and inside the country, refrain from detailing asylum seekers, and improve living conditions in transit reception facilities. The state party asserted that its legal regime is consistent with the European system. They refer to various measures that have been taken, including trainings of the Border and Migration Department together with UNHCR. They state that asylum seekers are not held in closed centers, but are referred following pre-screening, that work to improve the infrastructure of transit centers is ongoing, and the Border and Migration Department has drawn up draft guidelines on procedures for treating foreign nationals who do not meet the conditions of entry. Here we give the state party a B1, noting the information provided by the state party on training in conjunction with UNHCR, which we welcome, and the other measures taken. We request additional information on measures taken to improve the implementation of pre-screening procedures at the border and inside the country. With respect to detention of asylum seekers, we give the state a B1, noting the representation that they are not held in closed centers, and requesting further information on the measures taken to limit the use of detention centers, and including data regarding aliens detained. And then finally, we give the state a B2 with respect to improvements in transit reception facilities, asking for further details on the restructuring of the reception facilities, as well as information on the improvement of living conditions and when this is expected to be finalized. So that's that's it for Albania. Thank you.
Muchísimas gracias.
Thank you very much for that explanation. Would any members of the committee like to speak? It appears not, and so we will accept the proposals for evaluation as proposed by the rapporteur. Thank you very much. And I now give the floor back to the rapporteur to move on to the next stage. You have the floor.
Thank you, sir. The next state is Finland. The concluding observations were issued in July of 2013. This is follow-up to the first reply, which was received timely in June of 2014. I'm sorry. No, this is follow-up to the second reply, which was received in May of 2015, but both replies were timely, which we would like to emphasize that we appreciate. Paragraph 10 addressed detention of asylum seekers requesting use of alternatives to detention, ensuring that administrative detention in immigration is only imposed in appropriate circumstances and is subject to periodic evaluation and review, and asking the state to improve living conditions in a particular detention center. In the follow-up, we asked for additional information on steps taken to revise the legislation on detention of aliens, progress on the legislation's adoption, alternatives to detention that were provided for in the legislation, guarantees in the legislation to ensure that immigration is justified as reasonable, necessary, and proportionate, and asked for additional information on the Metsala Detention Center. Here, the state replies that detention is only imposed as a last resort, that as a result of opening a new detention center, there's no need now to place aliens in police detention, that amendments to the Aliens Act were accepted by the Parliament, which we understand to mean this legislation has been implemented. The National Police Board, they state, will review instructions and make changes needed to comply with the new amendments to the Immigration Act, that alternative interim measures to detention are provided for in this act, although in that regard, I'll note that this is a reference to a different law, the Aliens Act of 2004, so that is not new information. Alternatives to detention for aliens are always considered, and they state that no national statistics are available, however, on the use of alternative measures. The Ministry of the Interior in January of 2015 launched a project to introduce specific alternative measures to reduce detention of minors and other vulnerable persons. Legislative amendments in this regard, they say, will probably enter into force in 2016. With respect to this, we give the state a B1, welcoming the amendments to the Aliens Act regarding detention. We request additional information regarding the legislative changes that were introduced, and additional information regarding the various projects launched by the Ministry of the Interior and the National Police Board to implement the new legislation. With respect to the conditions of the detention facility, we give the state a C2, welcoming the opening of the new facility, but this is not responsive to our concerns regarding the living conditions in the Metsala facility. So we ask for information reiterating our recommendation in that regard. With respect to paragraph 11 asks the state to provide the committee with information regarding compliance with the duty to bring a detained individual before a judge within 48 hours of apprehension, the right to access to a lawyer from the moment of apprehension, regardless of the nature of the crime. In follow-up, we expressed regret that legislative reform that occurred in 2014 did not implement the recommendation that individuals be brought before a judge within 48 hours of their apprehension. And we asked for further information on practical measures to ensure all suspects are guaranteed a right to a lawyer from the moment of apprehension. The state party's reply in the second follow-up says that their legislation is consistent with the established practice of the European Court of Human Rights that the maximum limit for bringing a detained individual before a court is 4 days. They state that most arrested persons are released within the first 2 days, that the Ministry of Justice in 2014 appointed a working group to explore possible alternatives to remand imprisonment. They state that there is a right to legal assistance, that in December 2014, new provisions were added to the Criminal Investigation Act, covering informing persons of the right to retain counsel of their own choice, and to have free legal aid and a counselor. So with respect to the right to be brought before a judge within 48 hours, we give the state a C1. We acknowledge the efforts of the working group and request information on its progress, but we express regret that the state party has not required legally that suspects be brought before a judge within 48 hours, and we reiterate our recommendation. With respect to access to counsel, we give the state an A. We welcome the new provisions in the new law in this regard, and we ask the state in its next periodic report to report on trainings for criminal investigation officials regarding these new procedures. In paragraph 16, we ask the state to advance implementation of the rights of the Sami by strengthening the decision-making powers of Sami representative institutions, to revise its legislation to guarantee their right to their traditional lands and their ability to engage in free, prior, and informed participation in policy developments that affect them, as well as to ensure appropriate measures to facilitate education in their own language. In the follow-up, we take note of a proposed legal revision and request additional information on its progress. We ask for more information regarding inclusion in legislative and other policy discussions, and with regard to implementing a nationwide action plan to revive the Sami language and its impact on education. Here, the state party replies that in September 2014, a government bill revising the Act on the Sami Parliament was submitted, but this was rejected by the Parliament and the whole bill was withdrawn. In November 2014, a government bill to ratify ILO Convention number 169 was submitted to the Parliament, and this is still pending. The state party refers to various aspects of its legal framework and notes that in July of 2014, an action program for the revitalization of various indigenous languages was approved by the government, and that the Board of Education has increased funding for training teachers regarding the revival of an immersion in the Sami language. The committee's evaluation. We give the state party a C1 with respect to the legislative proposals, particularly given the failure of the bill on the Act on the Sami Parliament, and we reiterate our recommendations. We give the state a B2 regarding measures taken to ensure that the Sami people participate in discussion of policy measures impacting them and the initiative to ratify the ILO Convention, and we give the state an A on its efforts to provide for education in the Sami language. Thank you.
Muy bien.
Thank you. Would anyone like to comment? Sir Nigel.
Thank you very much, sir. And I too would like to thank the Special Rapporteur for the report. This is probably, and I speak as a former Special Rapporteur on follow-up to concluding observations, the report that we have this time is probably as good a one as we've had, and the presentation by the current Special Rapporteur probably also falls into that category. The question I have relates to paragraph 11 of our recommendations. That's the issue of detention. Excuse me. First of all, I have a question in relation to point question of access to a lawyer. The state party's reply doesn't as such say that there is a right to a lawyer from the moment of apprehension. And so I'd like some clarification as to whether we're certain about that. There are three dimensions to our concern. We separated out A and B, being brought before a judge and access to counsel. Essentially, there are three dimensions to our concern, which is essentially one to avoid abuse of people detained. One is that they be brought promptly before a judge. Another is that they have immediate access to counsel. Another is that they be taken out of police detention as soon as possible. Now, I was very interested in the state party's reply referring to the possibility of introducing alternatives to remand imprisonment. What I'm not clear about is at what point the prisoners are taken out of the hands of the police. Because if they're taken out of the hands of the police within a 48-hour period, that too reduces the need for us to be dogmatic about being brought before a judge within 48 hours. Now, I'm not expecting the rapporteur to be an expert on Finland, but it would just be helpful to me, to this particular member, if that interrelationship were a little bit clearer. Thank you very much.
Muchas gracias.
Thank you. Any other colleagues wishing to speak? I don't see anybody. So, Ms. Cleveland, Rapporteur, has the floor.
Thank you, Mr. Chairperson, and I would like to thank Sir Nigel for his intervention. With respect to the right to access counsel from the moment of detention, the state provided us with fairly lengthy information, which we understand to indicate that the amended legislation includes the right to, quote, get a defender appointed and the right to get free legal aid and a counselor. This is what we were informed. And so it is our understanding that the state party has in fact provided for such access, and we are asking for further information on implementation. And with respect to the relationship between being promptly brought before a judge and treatment, would you like us to specify that relationship in the report?
Not necessarily, sir, is the answer to the rapporteur. I'd just like to have a better understanding of what the situation is, with a view to figuring out, as we break it all down, right to counsel, right to appear before a judge, and one thing which we don't put explicitly, but which is important, which is right to get out of the hands of the police, the investigating authorities. That interrelationship could affect the way we evaluate the outcome of the process, and so it's more a question of information that it might be useful to have if we don't already have it. And just finally, I'm reassured that we're clarifying that the right to counsel, which seems to be implicit but isn't explicit, being from the moment of detention, is still up for further clarification. But to the extent that it is, I wonder whether at this stage the A evaluation is appropriate until we have clarified that point. Thank you very much, sir.
Bien.
Thank you. Ms. Cleveland?
I will hand the floor to the Secretariat in a moment, but with respect to the interface between when you're brought before a judge, I can advise a little bit more about what the state told us. The state told us that the 4-day period is a maximum limit, according to their law, the official presenting the request and the judge shall act without delay. They say that their time limit of 4 days is within the lines established by the European Court of Human Rights. They say that most arrested persons are released during the first 2 days without the need to be brought before court. Shortening the time limit for bringing people before court could cause unnecessary requests for remand and lengthen the deprivation of liberty. And that the Ministry of Justice has appointed a working group to examine the possibility for introducing alternatives to remand imprisonment and the holding of remand prisoners in detention, the possibility of strengthening the supervision of compliance with the travel ban connected with remand imprisonment with electronic means, and of transferring the responsibility for the custody of remand prisoners from the police under the Ministry of Interior to the Ministry of Justice, and the impact of transferring such responsibility, and they're supposed to report back at the end of this year. So they're basically sticking with their law, and they have a working group to look at possibilities for reducing the length of custody in this regard, but they are not willing to accept our recommendation at this point of a 2-day period for being brought before court.
Bien.
Sir Nigel.
Briefly, so that's extremely helpful information. One of the things I think it might be useful for us to do, and I'm not sure I can do the drafting right now, but I'm perfectly happy to leave it to the rapporteur and the Secretariat, is to encourage the move from of remand detention from police custody to separate Ministry of Justice custody. I think that is very much a step in the right direction, would be very much a step in the right direction. It also clarifies that they consider police custody remand detention, which wasn't clear to me before, and which is not necessarily the usual means, the usual way of understanding remand detention. Thank you.
Bien.
Ms. Cleveland.
Thank you. Just to follow up on that last point, this is unfortunately in part a casualty of the severe summary that we have to give of the information provided by the state party in the final draft of the follow-up report. But I would be very happy to work with the Secretariat on that point. And I would also like to turn the floor over to the Secretariat to address Sir Nigel's question about access to counsel.
Tiene la palabra la secretaria.
Secretariat has the floor.
Thank you. I don't have much to add. It's true that the state party did not use the words of the recommendation, the committee's recommendation, and have not explicitly said that there is a right to law from the moment of apprehension. But as the rapporteur has informed, from the information provided by the state party, we understand that this is the right provided by in law. Thank you.
Bien.
Okay, I think we can agree then to keep the proposed assessment and add a short paragraph, find the right drafting to cover the concern that's been raised. So thank you very much, and let's move on. And this means we can adopt Finland and move on to Tajikistan. Ms. Cleveland?
Thank you, Mr. Chairperson. Tajikistan's concluding observations were issued in July of 2013. This is the first reply that was received late in March of this year. With respect to paragraph 16, this recommendation asks the state party to guarantee the registration of detainees and ensure ensure that all arrested persons enjoy their rights as required by the covenant, including access to a lawyer, family members, and medical personnel, and to establish an independent mechanism for inspection of detention facilities. The state party replies that the rights of detained persons are protected under its law, that in July of 2013, the Supreme Court issued a ruling that clarifies the legal provisions regulating detention, that law enforcement bodies have made efforts to ensure that detainees are informed of their rights, and that a recommendation to institute an independent mechanism for the inspection of detention facilities is under consideration. NGOs provide us with a range of information, including the fact that national legislation is ambiguous about when a person is considered a detainee for purposes of triggering legal protections, that the ICRC has not had access to facilities since 2014, that the Ombudsman's Office has established a civil society monitoring group, but they are not admitted to facilities, and independent monitoring is not regulated by domestic legislation. We gave the state party a C1 with respect to legal protections of detained individuals. We note the Supreme Court's ruling, but we ask for additional information regarding the moment a person is considered a detainee for purposes of triggering legal guarantees, as well as reports that administrative detention is used by the police to avoid these protections. We ask for additional information regarding implementation of the Supreme Court ruling and whether its recommendations are applied in all cases, the efforts of law enforcement bodies to ensure that detainees are informed of their rights, and also of their right to access to immediate access to a lawyer and a doctor, and whether they are applied in all cases. Now here, Mr. Shani, who could not be here this morning, submitted a query whether the C1 grade should be a B2 in light of the Supreme Court decision. Civil society has informed us the state party provided very little information about the content of the Supreme Court decision. Civil society informed us that it was a positive ruling, but that it was merely a recommendation and not legally binding and has not been implemented. And this is the reason for not giving the state party a higher grade with respect to that development. On measures taken to establish an independent monitoring mechanism, we give the state party a C1 also. Paragraph 18 asks the state party to intensify efforts to guarantee the competence, independence, and tenure of judges, extending their tenure, providing for adequate salaries, reducing excessive powers of the prosecutor's office, and to ensure that the conditions on membership of the bar don't compromise the independence of lawyers, and to create a state-subsidized legal aid system. The state references a judicial reform program for 2014 to 2016, a working group that has prepared a bill on the work of the legal profession, and a policy framework drafted by the Ministry of Justice to define the policy on free legal aid. So all of these are either references to existing programs or to work that is underway but not completed. Our assessment here is a C1 with respect to protecting the independence of judges. We request further information on the judicial reform program and its content, as well as specific measures taken since the adoption of the concluding observations on reform of the judiciary. We give the state party a D1 with regard to conditions of membership of the bar, because the state party did not address this aspect of the recommendation, and a C1 with respect to the initiative of the Ministry of Justice to draft a policy framework on legal aid, which has not yet been implemented, and we request further information in that regard. For paragraph 23 asks the state to bring the law governing registration of NGOs in line with the covenant, particularly Article 22 and 25. We ask the state party to reinstate NGOs that were unlawfully shut down and to refrain from imposing disproportionate or discriminatory restrictions on freedom of association. The state party contends that freedom of association is protected by the Constitution and that associations may appeal any refusal of an application or registration. NGOs tell us that since July of 2013, the situation regarding freedom of association in the state party has remained tense and that no effective measures have been taken. Instead, draft amendments have been prepared that would further limit the space in which NGOs can operate. We give the state party a C2 in this regard, regretting that they have not provided information on its efforts to amend their law, that no information has been provided with regard to measures taken to reinstate NGOs which were unlawfully shut down, and in general, we reiterate the recommendations in this regard. Thank you.
Muy bien.
Thank you. I'd like to ask if any member would like to take the floor. I see no requests. So I take it that we can adopt this evaluation with the proposals on the table. Mr. Shani, I'd remind you, proposed an alternative drafting in the first part, and Ms. Cleveland explained that C1 was her preference, so we can go along with what the rapporteur has proposed. Okay, so that remains, and let's move on to Nepal. Rapporteur, you have the floor.
Thank you, Mr. Chairperson. Nepal's concluding observations were issued in March of 2014. They responded to follow up in June of this year, and this is the first follow-up. With respect to paragraph 5 sets forth a lengthy set of recommendations with respect to accountability for prior gross violations of international human rights, including ending political interference in the criminal justice system, investigations, holding perpetrators accountable, creating a transitional justice mechanism, prohibiting amnesties for gross violations, ensuring appropriate compensation, restitution, and rehabilitation to victims, and adopting vetting guidelines to prevent those accused of violations from holding public office and being promoted. The state party provided us with a great deal of information, only some of which we were able to include here. In November of 2014, a bill criminalizing all forms of torture and inhuman and degrading treatment was submitted to the Parliament, which they say is in line with the CAT. Other bills have also been submitted, including the fact that the Council of Ministers has ordered a bill criminalizing enforced disappearances, as well as a bill on implementing the Geneva Conventions. Well, that a bill implementing the Geneva Conventions is under consideration. They state the judiciary is independent. Police and army personnel have received training on human rights and humanitarian law, and 855 officials have received departmental action in relation, or face departmental action in relation to human rights violations. They do not, however, give us dates or tell us what human rights violations were at issue. The Commission on Investigation of Disappeared Persons and the Truth and Reconciliation Commission were both established in 2014. The state party indicates that both are independent, and that the Supreme Court has ruled that these commissions cannot recommend amnesty for serious human rights violations. The state says it has provided financial and non-financial support to conflict victims, that it will provide effective remedies in response to the recommendations that it will receive from the Commission on on investigation into enforced disappearances and the Truth and Reconciliation Commission. And that with respect to vetting, they state that the existing laws relating to civil service, the Army, and the police provide for vetting. NGOs also provide us with extensive information, some of which we were able to capture here. Civil society claims that the torture bill's definition of torture does not meet that of the Convention Against Torture and includes a 90-day statutory limitation. They say that the lack of politically independent investigations continues. There's serious concerns about the potential effectiveness and independence of the Commission. Most victims of human rights violations remain without access to effective remedies, and that no information has been provided on vetting mechanisms. The response of another NGO is along the same lines. With respect to the recommendation that they adopt criminal legislation criminalizing gross human rights violations, we give the state party a B2, welcoming the draft legislation, but asking for additional information on the definitions of human rights violations that are included in the bills, the sanctions that would be provided, whether they provide for a statute of limitations, and the progress in legislative efforts. With respect to political interference in the judiciary, we give the state party a C1 because we have not received information on measures taken since March 2014. And we ask them to clarify the information they have given us in this regard. With respect to transitional justice mechanisms, we give the state party a B2, recognizing the creation of the Commission on Investigation of Disappeared Persons and the Truth and Reconciliation Commission, but asking for information on whether they are already functioning, what their human and financial resources are, and also their application of the Supreme Court ruling regarding amnesties. And we give the state party a C2 with respect to vetting, noting that the information they have provided us simply reiterates information in the prior report. For paragraph 7, we recommend that the state amend the National Human Rights Act to bring it in line with the Paris Principles, to ensure its independent and effective functioning, to amend the procedures governing the appointment of commissioners, to ensure that the recommendations that the commission issues are effectively implemented. The state's reply indicates that the National Human Rights Commission enjoys full independence in line with the Paris Principles, and they state that the budget and financial autonomy are ensured. Civil society has concerns about the transparency and objectiveness of the criteria for the appointment of commissioners, and notes that the government has not yet passed laws on staffing, budget, organizational structure, etc. Here we give the state party a C2, noting the election of the chairperson and commissioners, but requesting information. A C1, noting the election of the chairperson and commissioners, but requesting information on the procedures by which they were selected, as well as on measures taken to amend the National Human Rights Act, as we had previously recommended. In paragraph 10, we ask the state party to take practical steps to prevent excessive use of force by law enforcement officials, to eradicate torture and ill treatment, including by adopting legislation defining and prohibiting torture, a recommendation which overlaps somewhat with that under the accountability and transitional justice recommendations. We ask for training on torture and ill treatment for law enforcement personnel, consistent with the Istanbul Protocol, and that the state should ensure that allegations of unlawful killings and other violations are effectively investigated, prosecuted, punished, and remedied. The state party responds by highlighting its current legislation, and also states that in 2014 the Nepal police developed a crime investigation directive, and that the Attorney General has developed victim protection and inmate human rights monitoring manuals, and security personnel have been given training on excessive use of force. Civil society notes that incidents of excessive use of force continue to occur and not be adequately investigated, and that the Istanbul Protocol guidelines are rarely applied. The committee's assessment in this regard is a C2 with regarding to steps taken to prevent excessive use of force. We note that the information that the state party gave us does not clearly identify any measures that have been taken after March of 2014, when the concluding observations were issued, and we therefore reiterate the recommendation. With respect to criminalization of torture, consistent with our prior evaluation, we give the state party a B2, requesting specific information regarding the bill that is pending and its consistency with the international definition of torture. On trainings and investigation of torture and ill treatment by law enforcement personnel, we give the state party a C1, asking for information about the trainings that have been carried out or are scheduled to be carried out and the integration of the Istanbul Protocol into all training programs. And then with respect to investigation into unlawful killings, torture, and ill treatment by law enforcement personnel, we give the state party a D1 for the failure to provide information to the committee in this regard. Thank you.
Muy bien, muchísimas.
Thank you very much for that very comprehensive information. Would any member like to speak? I see Mr. Situlsingh, you have the floor.
Thank you. Once more, thank you to Ms. Cleveland and the Secretariat for the report. I have a minor question on the National Human Rights Commission in relation to paragraph 7. I see that from the NGO information, at least 2 NGOs are saying that the government appointed the commissioners to the NHRC in a relatively transparent process. However, laws have not been passed. And in paragraph 7, there are 2 parts to it. One is to amend the Act of 2012, and the second sentence refers to amending procedures governing the appointment of commissioners. Now, our evaluation suggested by the rapporteur is a C1. I'm just wondering, and I leave it to her to consider, as to whether this should not be a B2 evaluation instead of C1 evaluation, as to the manner in which as to the fact that the commissioners have been appointed in a transparent process. And we are, according to C1, we are still requesting for information. Thank you, Chair.
Muy bien, muchas gracias.
Thank you very much. I see no other colleagues, so I will give the floor. I apologize, Ms. Voltervel. I didn't see you. You have the floor.
Thank you, Mr. Chair. Well, I can confirm I agree with Mr. Situlsingh, because during the dialogue with the delegation of Nepal, there was a question with regard to the transparency of the recruitment of the members of the national institution. And then the delegation refers to their website where the information was there. So we got the wrong information from, in this case, the NGOs who told us that it was not transparent. And I went to Nepal on a follow-up mission, and the commission, the members were selected, and it was transparent. So I think that together with Mr. Situlsingh, we can propose a B2. Thank you.
Bien, muchas gracias. Señora.
Thank you very much. Ms. Cleveland, you have the floor.
Thank you, Mr. Chairperson, and my thanks to Mr. Situlsingh and Ms. Waterval. Based on the information that was available to us, we did not believe that the state party had responded sufficiently consistently with the recommendation. The recommendation is that the state party amend the procedures governing the appointment of commissioners to ensure a fair, inclusive, and transparent selection process, and to ensure that the recommendations issued by the NHRC are effectively implemented. Now, the state party did not amend anything. The state party contends that the commission is already enjoying full independence in line with the Paris principles based on their existing law. Civil society says that there have been no changes to the law to ensure the independence of the commission. And although one civil society group says the appointment of commissioners was relatively transparent, the others say it was not based on predetermined, objective, and publicly available criteria. So the fact that current commissioners may have been appointed in a transparent process, we did not feel was sufficiently consistent with the recommendation to warrant better than a C1. Now, if it is the case that the recommendation itself was based on incorrect information about the legal framework in place, as Ms. Waterval suggests, then I think we need to go back and look at whether in fact this is the case, because we shouldn't be criticizing the state for not having an appropriate legislative framework in place if they do in fact have such a framework. But that information was not presented to us by the state in its follow-up report to the recommendation.
Bien, muchas gracias.
Thank you. I don't think here we are trying to revise our observations that were adopted, though the adopted observations are definitive and we can't reopen them. What we are looking into is whether the recommendation that we made was complied with. And I think the rapporteur is giving us reason to believe that in accordance with the information we have, we can classify by C1. Can we go with that recommendation? I see no objections. So we'll proceed as such. Thank you very much. And we'll move on to Georgia. I will remind you, colleagues, that we do also have to go through the follow-up report on views. So we have to see if we can promptly finish the review of that report. Ms. Cleveland.
Thank you, Mr. Chairperson. And Georgia is indeed the last country in the report. The concluding observations were issued in July of 2014. The first reply was received timely in July of this year, and I will note that our evaluation with respect to all paragraphs is in the B range, which is very nice with respect to Georgia. Paragraph 13 recommends that the state, as a matter of urgency, should reform its system of administrative detention to ensure compliance with Articles 9 and 14. The state party replies that amendments to the Code of Administrative Offenses were adopted in August of 2014, reducing the maximum detention period for violations of entailing administrative detention from 90 to 15 days, and that due process rights are also contained in these amendments. A governmental commission was established to make recommendations on rule of law reform to the government. This commission advised that administrative offenses should be treated as minor criminal violations or crimes, with the result that safeguards from the criminal process would apply, but no administrative offense would be subject to imprisonment as a sanction. Based on the Commission's recommendations, the government has drafted laws in this regard that are currently being processed and will be submitted to Parliament in the fall of this year. Our evaluation here is a B1. We recommend the amendments that have been adopted by the Parliament, reducing the maximum period for administrative custody. We request additional information on measures in place to guarantee alternatives to administrative detention, and the standards and procedures for imposing and reviewing administrative detention. We give the state party a B2, seeking more information on the rationale behind the initiative to place administrative offenses under the criminal code, including specifically types of offenses that are included, and to what extent administrative detainees are being held in temporary detention facilities. And this is because in some states, use of administrative offenses results in abuse, and we're seeking clarification on what the reality is with respect to this reform in this particular law. Under paragraph 14, we recommend the state, as a matter of urgency, to follow up on its reform of the jury trial system and ensure fair trial guarantees. The state advises that the Ministry of Justice developed a draft law to reform the jury trial system. They detail the contents of this reform. They say the draft law will be sent to the Venice Commission and or the OSCE for expert input, and they plan to submit the draft law to Parliament in October of this year. Here we give the state party a B2 primarily because the draft legislation is pending and not yet implemented. But it does, and then we request further information regarding whether it is fully consistent with our recommendation for compliance with Article 14 and progress on the draft. And that's it for Georgia. Thank you.
Muchísimas gracias.
Thank you very much, Ms. Cleveland. I will ask our colleagues if anyone would like to speak. It appears not. Sir Nigel, you have the floor.
I want to go on to the next thing, but just one question. I noticed that all the recommended actions involve sending letters, and none recommend actual direct contacts between the special rapporteur and the state party. Have we abandoned that practice, or have we just concluded that no such contacts would be appropriate in any of these cases? Thank you, sir.
Gracias, Sir Nigel.
Thank you, Sir Nigel. I know that we are not abandoning that practice because in this same period of sessions, the rapporteur did meet with various different states, but we will pass over to the rapporteur to see in these cases whether there have been any meetings taking place. I would like to say that in relation to Paraguay, which is one of the states that appears in the report, the former rapporteurs on the follow-up of concluding observations, Ms. Cyberford and myself, met with the delegation of Paraguay, but this was before Ms. Cleveland was nominated as the new rapporteur. I will give the floor to Ms. Cleveland to inform us on whether there is any additional information there. Thank you, Ms. Cleveland.
Thank you, Mr. Chairperson. In response to Sir Nigel's question, we have been prioritizing taking the initiative to arrange meetings with states parties that fail to reply to follow-up after 2 notifications. So this session and the last session, I met with states that, had failed to reply after 2 requests from the Secretariat. In both cases, I'm pleased to state that the scheduling of the meeting prompted the state to provide its follow-up report. So these are successful in that regard. But with respect to follow-up to the actual recommendations we make in this report, I stand ready and available to meet with any state that we think it would either be helpful to have follow-up with or that would like clarification, either here during the session or in New York. So I'm happy to do that, although the occasion has not arisen yet. Thank you.
Muy bien. Muchas gracias.
Thank you very much. So with that, I would like to express my warmest congratulations to the rapporteur for the extraordinary report that she has provided together with the Secretariat. Its high quality and the clarity of presentation, as well as the responses given, really do bear witness to very, very hard work, and we really do appreciate that. With that, we can adopt the follow-up report to concluding observations. We're now going to take a 5-minute break so that the colleagues can have in front of them the follow-up report on views for individual communications, and we will go on to review this in 5 minutes' time.